Konnichiwa. Welcome to Chocolate with Ed Garcia. I'm Ed Garcia, and this is chocolate. Today we have Fujiya Home Pie from Fujiya. I don't know what this is. Let's find out. I hope it's chocolate. Uh-oh. It's not chocolate. It's I don't know what this is. Some kind of crunchy cracker. Okay. Well, I guess today is not chocolate with Ed Garcia. Let's continue. Today, speech 22, United States Federal Courts. We're going to talk about SCOTUS, the Supreme Court of the United States, SCOTUS, and Ruth Bader Ginsburg, who died last year. And we're going to talk about CAFC, the Court of Appeals for the Federal Circuit. Specifically, we're going to talk about Circuit Judge Pauline Newman and a case called Ota v. Fiat. Very interesting case. Now, the Court of Appeals for the Federal Circuit is one of the United States appellate courts. There are 13 circuit courts, and the Court of Appeals for the Federal Circuit is one of them. And it is the only one that hears appeals regarding patents. So it's very important to patent attorneys. Now, under the appellate courts, we have district courts. These are the trial courts where experts come in and testify, and witnesses testify, and where the trial happens. Continuing. So, we're going to talk about number 1, SCOTUS, the Supreme Court of the United States. Number 2, CAFC, Court of Appeals for the Federal Circuit. Number 3, the U.S. Courts of Appeal for Circuits. These are called circuit courts, and as I said, there are 13. And then United States District Courts. As an example of United States District Courts, we're going to talk about the 4th District, which includes the state of Virginia and some other states. Inside the 4th District, there's a Western District and an Eastern District. And the Eastern District of Virginia is one of the districts in the 4th District. So let's continue. So, Supreme Court of the United States is authorized by the United States Constitution, Article 3, Section 1. So all of these courts that we're discussing are called Article 3 courts. They're very powerful, and they're empowered. They're given power by the United States Constitution right here. We talked about Ruth Bader Ginsburg, RBG. This is her official portrait from 2016, when she was very young. And she kept getting older, and then last year, 2020, she died, and she was replaced. She was replaced by this lady. So as you see now, this is the Supreme Court of the United States right now in 2021, and there are, of course, 9, and always remember the rule of 5. The rule of 5. If you can get 5 votes on the Supreme Court, 5 out of 9, 5 out of 9, you win. You can do things like, for example, decide who is the president. In the year 2000, some cases from Florida went all the way to the Supreme Court, and the Supreme Court decided that George Bush, became president. And right, this is a very powerful court. And in the year 2020, they decided that Mr. Biden would become president. They decided that by refusing to take certain cases that might have reached a different conclusion. The Supreme Court said, no, we don't even want to listen to these cases. We will not grant certiorari, which means permission. Certiorari means they certify the petition for appeal. There is no right of appeal to the Supreme Court. Let me rephrase that. You can appeal to the Supreme Court, but the Supreme Court may not accept your appeal. They're very busy. And when they decide a case, they all listen to the case. All 9. Occasionally one is sick, or one says, I cannot perform. Maybe my brother is in the case, so I have to recuse myself. And sometimes there's an empty seat. Someone has resigned or died, and the seat has not been filled yet. In those cases, there are 8 justices. Continuing. So the newest justice is Amy Coney Barrett. We can call her A for Amy, C for Coney, B for Barrett, ACB. And she replaces RGB, Ruth Bader Ginsburg. Now, the CAFC, the Court of Appeals for the Federal Circuit, handles all patent appeals. And it is unique among the circuit courts, the courts of appeal, because its jurisdiction, its power, is based on subject matter. It's based on the issue. And so it covers certain subjects for the entire United States, such as patents. When you appeal a patent case from any of the 94 district courts, it goes to the Court of Appeals for the Federal Circuit. Here are the justices, the judges, for the Court of Appeals for the Federal Circuit. Look how many there are. Now, 12 of them are active judges, which we just call judges. And then 7 of them are what's called senior judge. Now, a senior judge is semi-retired, almost retired. The senior judge only has one court clerk to help them, so they only take a few cases. They like to go to the office and have lunch with their friends and keep getting paid, but they don't do very much work. They're half retired. But all federal judges, Article 3 judges, are lifetime appointments. So once they're appointed and confirmed by the U.S. Senate as being a judge, let me rephrase that, they're nominated by the president and they're confirmed by a majority of the Senate, and then they become judges for life until they die or until they retire. So, who's the oldest? Well, that is Pauline Newman. Let's talk about Pauline Newman. She's 93 years old. She's very happy. Okay, so as I said, there are 12 active circuit judges and there are 7 senior judges. Now, usually when they work in panels of 3, only 3 judges, so a majority of 3 is 2. Occasionally, they will all get together and listen to a very important case, and we call that en banc. En banc. I don't know why they use French, but usually only 3. So if you have 12 active circuit judges in groups of 3, they can create 4 groups of 3, 4 panels. So they can easily listen to 4 times as many cases as the Supreme Court, right? Because they work in groups of 3 instead of a group of 9 like the Supreme Court. Now, let's talk about Judge Newman, Judge Hughes, and Judge Stoll, which were the panel of 3 judges for the case Otta v. Fiat Chrysler. Fiat Chrysler, and many other defendants. All right, so here's Pauline. She was born in 1927, and she's now 93 years old. This picture is a few years old. I tried to find a older picture of her when she was very young, but I cannot find pictures of her when she was young. She's a very interesting lady, Pauline. Now let me tell you, I've read many cases written by Pauline Newman, but I just saw Newman. I did not know it was a woman. I did not know it was Pauline. I don't know why. I always assumed it was a man. But it's not. Pauline is a very old woman, 93 years old. She has her Bachelor of Art from Vassar. I think Vassar's an all-woman school. I'm not certain. She has her Master of Arts from Columbia University, and these are in chemistry and in chemistry. And she has her PhD in chemistry from Yale, yay, in 1952, before I was born. And then she worked for a few years and then went to law school and got her Bachelor of Law, which is what it was called then. Nowadays, usually it's called a Juris Doctorate nowadays. But Bachelor of Law, her law degree, from New York University in 1958, before I was born. So Pauline Newman has been an attorney for longer than I have been alive. And you see this gray hair? So she is very old. Now, in this case, Utah v. Fiat Chrysler, she wrote the opinion, and Claim 1 said, the book holder comprising a book support platform which has a front surface adapted for supporting a book. Now, Judge Newman made 4 decisions regarding interpreting this claim, and one of the things she said, the first thing she said was, the district court, that's the trial court below, that appealed to the Court of Appeals for Federal Circuit because it's a patent case. So Newman says, the district court correctly found that the book holder cannot include or be the equivalent of a camera holder. Interesting. So what was happening was OTA was suing many people, including car companies, for many things, including devices that held cameras. So Judge Newman says the district court correctly found that the book holder cannot include or be the equivalent of a camera holder. I have to say, I think I disagree with her on this, but let's continue. Here are some original drawings from the patent application. These are the original drawings, the first set of drawings, not the final set of drawings. You can see they're hand drawn, and the original drawings show a front white board here. This is a whiteboard, so you can draw on it with a whiteboard markers. And let's look at another picture. So this one says, book cover is closed tight. Book cover is closed tight. So this appears to have a book in the center, a book opened, and then the book cover is closed tight. So the book cover looks like it pushes on the edges of the book. Book cover. Now the claim does not have a book cover. Well, let's just continue. And this is another original drawing, and this one has some clasps down here to hook onto something, a pipe perhaps. Now, this is the drawing, I think figure 1 in the final formal drawing that was used for the published patent, the issued patent. Now, Claim 1 says, a book support platform, the front surface adapted for supporting a book. Well, how? In one of those figures we saw a book cover, but here we have a plurality of clamps disposed on the front surface to engage and retain the book. Did you see any clamps on those figures that we saw and the original figures? I don't think so. So I'm not sure whether this clamps was actually supported by the original application, which was very informal. Speaking of book holders, remember Thomas Jefferson was the first patent examiner. He was the second vice president of the United States, and he was the third president of the United States. But most important, he was the first examiner, first patent examiner. Hooray for patent examiners. In the house of Thomas Jefferson, in the basement, they found this thing without books. It was folded together. You see this lifts and folds, and this lifts and folds. And when they opened it, they did not know what it was. The historians, the people in charge of taking care of the house of Thomas Jefferson, which of course is a museum now in Northern Virginia. They thought, the historians thought, that this was a music holder. You put music here, and maybe you play your violin or your flute. It could hold music, right? This could hold music. But after further consideration and perhaps some experimentation, they said, look, this is sized for a big old book like this one. See, and you see the lip, the platform on the bottom here to hold the book, and it's big enough where you can slide the book here and open it. So Thomas Jefferson could look at 1, 2, 3, 4, 5 books almost at the same time. If he stood here, he could look at 1, 2, 3, and then rotate it to look at 4, and then rotate it more to look at 5. But he could look at 3 relatively easily, or certainly 2. So this is similar to many people today have multiple monitors on their desk. Some people I work with have 4 monitors. It's a little bit too much, but okay. Here's some very interesting things about this patent. So it has 4 inventors named, they're all named Ota. Inventor 1 is Chineye, Inventor 2 is Chika, Inventor 3 is Kenneth, Inventor 4 is Chikezie, I don't know. Where are they from? Nigeria. These people are from Nigeria. All of these inventors are from Nigeria. And it looks like ConWorks Corporation is a book company in Nigeria. Chikezie Ota sued all of these people. Chikezie. Oops, let's go back. Chikezie. This person. So inventor number 4 is filing the lawsuit. VP, Vice President of ConWorks Corporation. It does not say who the president is. Maybe none of these people are the president. I don't know. Okay, so Chikezie Ota sued everybody. These people and other people also. Many people. So let's talk about the geographic boundaries of the appellate of the courts of appeal, which are circuits. The geographic areas are circuits, and specific United States district courts. So this picture shows everything. It shows the circuits, of which there are 11 with numbers, plus the Federal Circuit, the Court of Appeals for the Federal Circuit, right here. They just call it Fed. And of course, it's located in Washington, D.C., and it's a beautiful building, and I've been there. I've watched a case argued in the Court of Appeals for the Federal Circuit, of course, a patent case. It was very interesting and very powerful. The United States government, of course, is located, the capital is Washington, D.C., and so there's a lot of money there. And there are some very wonderful buildings, very old, very large, very beautiful. And one of them is the courthouse for the Court of Appeals for the Federal Circuit. It's wonderful. And there was a period of time when I worked very close to the Court of Appeals, and sometimes I would get out of the subway, out of the train a little bit early, and I would walk a little bit. I would walk past the Court of Appeals for the Federal Circuit building. I would walk past the United States Treasury, where they print money, one of the places that they print money. I would walk past some museums. I would see in the distance the Washington Monument. You really feel the power. You feel the power in Washington, D.C. So where was I? Okay, so there are 11 geographic districts, or maybe 12 if you count DC. So let's say 12 geographic districts, and then the Federal Circuit, the Court of Appeals for the Federal Circuit. So 12 plus 1. Now, for example, if you look at number 9, which is very famous because California is in it. So the Ninth Circuit, and the Ninth Circuit has a large number of districts. One of the districts is the Western District of Washington, the Eastern District of Washington, Oregon, Idaho, Montana, and then Nevada. California is split into 4 districts. The state of California, which is part of the Ninth Circuit, has 4 districts inside California. But more important, let's talk about the Fourth Circuit. Why? Because that's where I live. So the Fourth Circuit includes Virginia, West Virginia, North Carolina, and South Carolina, and Maryland. And Maryland. Now, the state of Virginia has two districts, the Western Virginia and Eastern Virginia. So let's go from top to bottom. We have the Supreme Court of the United States, and then for patents we have the Court of Appeals for the Federal Circuit, and then among the geographic circuits we have the Fourth Circuit. That's where I live. That's the most important one. And it includes the state of Virginia, which includes two districts inside the state of Virginia. So the Fourth Circuit has, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9 districts. So here we go. The Fourth Circuit, here it is. The United States Court of Appeals for the Fourth Circuit is one of 12 regional appellate courts. So regional appellate courts defines the Washington, D.C., the D.C. appellate court, the D.C. Circuit as a regional appellate court, which makes sense, it is. And the court hears appeals from the 9 federal district courts in Maryland, Virginia, there's 2 in Virginia, West Virginia, North Carolina, I think there's 3 in North Carolina, and South Carolina, and from federal administrative agencies. Continuing, like I said, there are 2 district courts in Virginia, East and West. The big one is the U.S. District Court, Eastern District of Virginia. It's abbreviated like this: ED, Eastern District, VA, Virginia, Fourth Circuit. So it's the Eastern District of Virginia, which is a district in the 4th Circuit. And it's located in Richmond, Virginia, the capital of Virginia. And this Eastern District includes 85% of the population of Virginia. The other one is the Western District of Virginia. Continuing, here are all the district courts in Virginia, of which there are 2. So here's the Eastern District over here, and these are the counties. And here's the Western District. So about half of the area is in the Eastern District. Continuing, here's my cat, Bonnie. How did Bonnie get into this PowerPoint presentation? I don't know. I guess because Bonnie lives in the 4th Circuit in the Eastern District of Virginia. Hello, Bonnie. Here are the resources and links. Remember, Chocolate with Ed Garcia on YouTube, and you can watch this speech and many others. This is the end of Chocolate with Ed Garcia. We talked about the United States federal court system, and we talked about my cat Bonnie. This was the best speech ever. We had chocolate, well, no. We had Fujiya home pie. Next time we'll have chocolate. And we talked about my friend Ruth Bader Ginsburg from the Supreme Court, who passed away last year. And we talked about my other friend, Judge Pauline Newman, who is 93 and active. She's not retired. She's not senior status. She's just writing opinions. And this was the best speech ever. Mount Fuji. This one is red. I like red Mount Fuji. Sekiya Village on the Sumida River. That's what this one is. Sumidagawa Sekiya no Sato. And we have horses. 1, 2, 3 horses. Running fast. Very nice. Let's zoom in on one of the horses. Notice what the artist did in this wood print. Look at the face of the rider. You cannot. Humans instinctively want to look at the face of people in pictures and in paintings and in wood prints. But you cannot see the face. When you cannot see the face of the rider, what do? You look at the face of the horse. Look at the horse's face. He has big eyes, and he's running hard, and he's kind of excited. He's happy. He's running. He feels strong and good. And the wind is blowing these straps. Look at the where the rider places his foot. Look at the stirrup. In English, we call this a stirrup, but its shape and design is very different than United States custom. This is a very different shape. It's like a platform to a flat platform to put your foot on top of. In contrast, very differently, the United States stirrups, part of the saddle where you put your foot, are shaped very differently. They have at the bottom usually a bar of iron, and then sometimes a whole thing of iron, and it's attached to leather here. So you bring your foot through the stirrup and press it down. And for this reason, the horse riders in America have heels on their boots that go down like this. They wear boots. And one of the reasons is so that when you put your foot in the stirrup, the heel catches against the stirrup, so it makes it very stable. Your foot does not move. You use your heel the front part of the heel to lock against the stirrup. And to get your foot into the stirrup, you take the front part of the boot and you make it pointy. You make it sharp, so it has a sharp, pointy edge. So when you see cowboys wearing boots and the front of the boot is very pointy, very sharp, this is a design for riding horses. Very interesting. Now this heel, use of the heel, I know about this because it's the same thing with a motorcycle. When you drive a motorcycle, the motorcycle has a foot peg, and you put your heel against it, and this gives you good control. Your foot doesn't slide off because you put your heel against it and then point it down a little bit. So let's say this is the heel. So let's see, how can I show this? So I'll show it here. You push the heel against it and then tilt down a little bit. So you're locked in. It's almost grabbing it. Oops. I messed this up. All right. Okay. So wonderful detail. Beautiful horse. I love this painting. Fuji-san. Arigatou gozaimasu. Sayonara. 日本が大好きです。